Okay, well, I've got 12:01, so get this going here in a second. Okay. All right. I think we're all set up. All right. Welcome to the November webinar for the HR Best Practices series. This month, we are going to talk about accommodating disabilities in the workplace. Title is Accommodations. They go round and round, and I promise not to sing that to a tune. I'll spare all of you, especially since this is being recorded. It is being recorded, so those of you who are members of the HR hotline will be able to access this and watch it as many times as you would like in the future, or have other people in your organization watch it as well if they weren't able to attend. For those of you who have indicated that you are certified by HRCI and SHRM, this webinar has been approved, and as long as you indicated it on the when you checked in, when you signed up for the webinar, you should be receiving an email with your certification and the number so you can claim those credits. My name is Kevin Mosher, and I have been doing this webinar series for many years, since 2012 when I joined Thompson Co., and I'm a partner at HR MSBA Certified Labor and Employment Law Specialist partner up in our Minnesota St. Paul office for Thompson Co. All right, so this month we are going to talk about, there we go. We are going to talk about disabilities. We're going to talk about accommodations. It is a challenging area. So just overall, this is a very challenging area for employers. I think one of the reasons it's so challenging is because there is just no objective standard. And we'll talk about all this in detail, but if I'm just relaying my general thoughts, it is hard to know. First of all, we're not doctors. Unless you're a doctor. If you're actually a doctor, then you are a doctor. But most people in HR are not medical professionals, and yet HR people and companies have certain burdens when it comes to handling and accommodating employees who have disabilities, and where those disabilities are affecting the employee's ability to perform their job. And so it is hard as lay people to understand what really the accommodations, what accommodations might be necessary, as well as whether or not the person really truly does have a disability and how that is impacting them in the workplace. So we're called upon to in a way play doctor. I strongly discourage you from pretending to play a doctor if you're not. It just creates legal issues for you and the company, but still, that's kind of the pseudo responsibility that we have, and yet the law then is created to put the burden on employers to do something. And if the employer doesn't do something about it, and they don't have an approach, and they don't handle the situation appropriately, and the employee gets fired as a result because they can't do the job, and there's oftentimes a lot of pressure from lower level supervisors and managers who care about productivity and profitability and that sort of stuff. They don't care so much about the legal issues generally regarding these employees. As HR professionals and lawyers in this realm, we do care. So there's often a schism between lower level supervisors and managers and HR and legal regarding what needs to be done and how much needs to be done, because so often the more frontline managers and supervisors want the person gone because they're just not contributing to the team. Okay, so we are going to talk about an approach today, and we are going to talk on here. You see the interactive process listed as the 5th bullet point. We are going to talk about that. We are going to talk about what we need to do and how we need to train supervisors and managers, assuming hopefully they immediately notify HR when these sorts of disabilities in the workplace, these issues arise. But often they don't, and so if you are doing training for them, we really need to pound into their heads what this interactive process is. Okay, let's skipping ahead a little bit. Here are the contents. We are going to talk about the laws, why we care, what the laws are. For those of you who attend my webinars frequently, on a monthly basis, you probably have gathered by this point, I don't focus on regurgitation of legal standards and the law. I find it just to be distracting. So I'd rather, this webinar series is really about best practices and how to actually take those laws and to put them into an approach so that you as HR professionals and other people dealing with HR issues in the workplace can handle those, synthesize those laws to lower your risk and hopefully to comply with the law as best you can. Okay, there are the contents. Jumping in the law, not going to, that said, here's the law. So we're not going to focus too much. I will say, so, the ADA, right? And then it was amended in 2008. In 2008, really, if you're not familiar with the amendments in 2008, it basically said most people in the United States have some sort of disability. They really watered down the definition of what a disability is. When I was a newer lawyer back in the day, pre-2008, and when we would have cases or we'd be responding to the EEOC or various state agencies on these sorts of disability claims, we legitimately would argue that the person's not disabled. Now that's always very difficult because, HR person or lawyer versus doctor on the stand. Doctor says the employee is disabled. We are going to lose every single time. But when we're arguing to the EOC, they don't know any better, and they don't know if a person's disabled, and we would argue and be successful frequently that the person is not, quote, disabled under the Americans with Disabilities Act. That defense became much harder in 2008, and so as a result, unless we have really strong information or evidence that the person is not disabled, that they're faking it, or that their condition is, like a common cold, something that is temporal and is going to expire in the near future. It's going to last weeks or days or maybe even a few months. Then it's not going to be a disability. But otherwise, if it is a chronic type of lingering condition that the person has, like allergies or cancer, something like that, like Crohn's disease, something like some sort of disease long-term effect, it's a pretty good guess that the person is going to be considered disabled under this law, so under the federal law. And then you do have state laws, and we're not going to talk about those, but there are state laws on this as well. And Minnesota is a really good example of a state that waters down the ADA even further by making it even easier for somebody to be considered disabled. So when you're approaching employees, just to kind of put this into a context, I wouldn't spend a lot of time trying to play medical doctor in trying to figure out whether or not the person is disabled or not disabled under the ADA. For purposes of determining an approach to them, I think just assuming that they probably are disabled under this act, and in good faith then talking about accommodations and getting medical information from them. Obviously we can ask for medical information to corroborate this, but at the front end, I wouldn't just send somebody out of your office because you don't buy into their story that they have some sort of disease that you can't tell on its face that it is a disabling condition. We are going to briefly talk about the Family and Medical Leave Act, which is the federal law, and it might not cover all of you on this call. It does only cover employers with 50 or more employees, and then the employee has to also be eligible, and I'm not going to get into that, but suffice it to say, if you are covered by the Family Medical Leave Act, there is definite overlap with the ADA, and we'll talk about the interaction there, and I think I even have a fancy chart that shows the distinctions between the two. But there is an issue with the FMLA, because somebody who is covered by the FMLA and is entitled to 12 work weeks off per year, for a serious medical condition or pregnancy or whatever, but a qualifying reason under the FMLA, that person it doesn't necessarily mean that they are disabled. So somebody might be eligible and they might take get their 12 weeks off. Like pregnancy, for example, is not covered by the ADA because it's a condition that ends, right? So after about 9 or 10 months for a lot of people. So it is not going to be a disability, but pregnancy is going to be covered by the FMLA, and the female is going to be, the mom is going to be entitled to the 12 weeks off if they're eligible. So just an example where somebody could be eligible under the FMLA but isn't necessarily eligible under the ADA. Under the ADA, what does the ADA prohibit? Okay, it's only really two things. It's discrimination based on disability is a protected status, so it's one of the protected statuses like national origin and race and age and religion and that sort of stuff, citizenship, or a bunch of them. So disability is considered one of them, and the ADA does prohibit discrimination. It also prohibits retaliation, and retaliation is the new, more in vogue way to get at causing liability to employers. So that's the last 5 or so years. Retaliation's kind of been the big go-to claim, both in lawsuits and at the agency level, that are being asserted against employers. The ADA does specifically require, and by the way, a lot of state laws require this as well. So if we were in Minnesota, if you're in Minnesota, Minnesota law requires, prohibits the same stuff and requires, reasonable accommodations unless it would cause an undue hardship. But at the federal level, exactly the same. So it does require that you provide a reasonable accommodation so that the person can perform the essential functions of the job, unless that accommodation would cause an undue hardship to the business, or be a health risk to the employee or coworkers. So that is an absolute requirement, that we need to provide reasonable accommodations, and we'll talk about what reasonableness is, and we'll talk about undue hardships, but the law specifically requires that we do provide reasonable accommodations. This is not an option. This is not something that, if the employee comes and they ask for a reasonable accommodation, that we say, you know what, we just can't do it. We hired you with the expectation that you produce so many widgets on the line, and you're coming in and you're saying that that your hand is really hurting, and you've got arthritis, and now you can't produce those widgets. If you think about like Laverne and Shirley, right? And they've got the bottles. They're in Milwaukee, right? Of course, bottling factory, and so they've got to use their hands, and they're moving the bottles, and Laverne comes in and says, "Hey, I can't do it. I've got arthritis." Well, you can't just send her out the door packing. That is essential that she moves those bottles around and everything, but we need to go through, and we'll talk about the interactive process. We need to go through a process, and you have to have a process in place. Otherwise, you're going to be opening yourself up to definite lawsuits if you don't have a process in place of actually having a conversation with employees about how you can provide a reasonable accommodation. We never want to jump to undue hardship. It's going to be an undue hardship. Undue hardship, it's going to cost the company money. It's going to put us out. It's going to slow down productivity. We never want to jump to undue hardship. That is a last course of defense, a last defense. But at the front end, we want to explore whether or not somebody can be reasonably accommodated, because that is absolutely required by the ADA and various state laws. The ADA covers employers. If you are a very small employer and you have less than 15 employees, you are not covered. So congratulations. Still, you want to take a look at state law. Here in Minnesota, for example, the Minnesota Human Rights Act covers all employers with 1 or more employees. So, sorry to burst anybody's bubble that has fewer than 15 employees, but if you have 15 or more employees, under the federal law, you are going to be covered, and those employees can be full-time or part-time. And then the law protects against qualified individuals with a disability. It also protects applicants and employees, and a lot of times the protections for applicants are lost in this conversation. And so I want to point out to you that in the application process, if there is a request for an accommodation, like for example, wheelchair access to the room, the person can't get up to the second floor and your facility doesn't have ramps or an elevator that would take somebody to the second floor, you're under the law, you would be required to explore reasonably accommodating that person so that they can still interview for the job. It's not just employees. Employees get all the a lot of the volume here, and they get a lot of the press, but it does include applicants as well. Okay, so again, I'm just going to look at each one of these. These are all requirements under the reasonable accommodation. So the ADA, so you are required to offer a reasonable accommodation. Again, we'll talk about what reasonableness is, because the confusing part is that's not an objective standard. It is going to be entirely subjective, and so I cannot sit here and tell you what is reasonable for your business. I cannot tell you, and if I told you what was reasonable in my estimation for one job, it would, and in Department A, it would not necessarily be reasonable for another job in Department B. We have to look at every single one. There cannot be an across-the-board approach to this. We have to look at every individual situation to determine what reasonableness is. It applies only to qualified employees, qualified applicants, so they have to be qualified for the job, so qualified individuals with a disability. So qualified individuals or qualified applicants with a disability, and what that means by qualification, again, I think I have a slide on this later, but what it means by qualification is that with or without a reasonable accommodation, that person can still perform the essential functions of the job. So I'm a lawyer. If I'm applying to be an engineer, if I'm applying for a job, and let's just pretend that I'm disabled in some capacity, and if I'm applying to be an engineer somewhere, I still have to be, the ADA is not really going to, I'm not qualified. So I don't have the skills, I don't have the education to be an engineer, and if my disability, and let's just say I did have the background and the education to be, I still need to be qualified because of my disability. If I've got an engineering degree and I was top of my class, or top of my class, engineer, and I've applied for a job, but I was on the golf course, and I'm a really, really bad golfer. I would just say probably a complete hack. I hit the ball to see how hard I can hit it, and I don't really care where it goes. And let's just say, because there's a pretty good chance of this, that I swing so hard and I hit myself in the head and have some sort of brain injury. And as a result of the brain injury, I'm not very good at engineering any longer. Let's just say that. And so I wouldn't be qualified because there's no way to accommodate. I've got a brain injury. I've lost a lot of my ability to do the stuff that's required of this engineering position, and so I wouldn't be qualified. So the ADA is not going to protect me because excuse me, I'm not qualified because I with or without a reasonable accommodation, I just can't do the job. That's this job. I might be able to do other jobs at the company, but I can't do this one. I can't do an engineering job with given the disability that I in my imaginary mind just created. Okay, if the accommodation is necessary for the employee to perform the essential functions of the job. So if you've got some sort of disability and it has no impact whatsoever on the essential functions of the job, you really don't have to reasonably accommodate it. We want to, before making that determination, we need to really double check and make sure that we're solid on that determination that it's not going to impact the essential functions. But technically, if the accommodation is not necessary to perform the essential functions of the job, then you really don't have to make an accommodation, an accommodation for them. And then the benefits, rights afforded to applicants who don't have a disability. The defenses that we can raise on the accommodation, again, this is backup plan, but we can examine if we cannot reasonably accommodate the person, or if the reasonable accommodation excuse me, would create an undue hardship on the company, then we can raise that as a defense, and we can deny the request to do the accommodation. If it's not necessary, again, like for the essential functions of the job, if it's unreasonable, and again, that's a subjective standard that we need to understand for every single job. And by the way, if I don't say it, this is why we have job descriptions. We have job descriptions so that when we have employees or applicants come to us and say, I've got this disability, and as a result, I need this accommodation, and if that disability is narcolepsy, and the person doesn't know when, I'm imagining, I just imagining what narcolepsy is, based on what Hollywood tells me. So let's just say the person falls asleep whenever. They don't know. They could just fall asleep randomly. They would have no notice of it. And if the job is climbing window washing, and that and falling asleep is a problem for the safety for the employee, well, we want to, it's good to have job descriptions. Now, that one's an obvious one, but we want to have job descriptions because the job descriptions are going to be informative of what the essential functions are. So if you don't have job descriptions, you're immediately putting yourself at a disadvantage when it comes to accommodation issues, because you don't have documentation showing what is essential in this job. And so that's a potential problem for you. So I would encourage everybody to have job descriptions, and it'll only help you with this. And then to update the job descriptions so that the job descriptions are accurate and appropriately relay the qualifications for the job and the essential functions. The employee is not qualified, so you've got my engineer brain injury example, and then the person's just not disabled. And again, these are backup defenses. We first want to take a look at reasonably accommodating. Okay. So what is the essential function of the job? This is the definition of the essential function. It's fundamental, crucial duties for the position. These are the things that should just kind of be obvious, but again, we want to have job descriptions that make it clear, that do some sort of documentation for this, and tell the courts or tell the EOC that, hey, it's required for Laverne that she does so many bottles, that she's picking up the bottles, that she's putting them in different areas. And so if Laverne, has arthritis and that prohibits her, that's going to be a problem because it is essential. It's hard to argue after the fact that something is essential when there's a dispute on it, if it's not in the job description. So we really want job descriptions to determine make our case for what an essential function of the job is. What determines whether or not an accommodation is reasonable or unreasonable? There it is. It's the circumstances. It's a subjective look at the situation. Again, what is reasonable for one job, for one department, is not necessarily going to be reasonable for another position in the same company at another department. Same as what is reasonable, for example, at a small employer, let's just say an employer with 25 employees. What is unreasonable for a small employer to accommodate could be entirely reasonable for a very large employer, especially when we're talking about cost and we're talking about other things. Larger employers just generally have greater resources to accommodate. That's not to say that larger employers can never say something's unreasonable, but a larger employer probably has a little bit greater means than a smaller employer does with regard to certain types of accommodations. And so again, what's good for one might not be reasonable for another. Who are the qualified employees? Qualified applicants, people who have the requisite skills to perform the essential functions of the job. Undue hardship. So take a look at these five things. If you're going to make the undue hardship argument, and you definitely should not be, relying on this and jumping to this, and certainly before you put in writing that you're denying somebody because of an undue hardship, you should talk to legal counsel about it. But the factors to consider. For the undue hardship, you can see them there: nature, cost, impact on the available financial resources, overall financial resources. So what's an undue hardship for a 25-person company is probably not financially going to be an undue hardship for General Motors. Nature of the employer's operations and the impact on the operations, impactability. for employees to perform. So these are our defenses that we can raise on the undue hardship stuff. Elements for a reasonable accommodation. These are the requirements. So is the person qualified individual with a disability? Do they know or should have known about the disability? An accommodation was available to the employer that did not unduly burden it, so undue burden, and the employer failed to make the accommodation. So this is what employees prove with their legal counsel or the EOC. This is what they argue, that the person was qualified, they had a disability, the employer knew about it, so there is a knowledge element. But knowledge can come from either direct knowledge from the employee or from somebody else telling the employer, or knowledge can also come from the circumstances. And knowledge coming from the circumstances is hard. A lot of times HR just doesn't know, but supervisors and managers might know that the person just keeps falling asleep at the job, and so something needs to be done, but a lot of times those managers just haven't been trained well enough to inform HR, and so no accommodations made. You can see the situation kind of getting out of control, and then the manager wants to fire the employee who keeps falling asleep at the job. An accommodation was available to the employer that didn't unduly burden it, and then the failed to make the accommodation. That's how they prove that. You're going to lose your case. Okay, let me see. Somebody raised their hand. They might have unraised it. I should have said there is the ability for you to. Oh, somebody just raised their hand. Yeah, we don't have interaction right now on. It's not opened up for everybody to talk, but you are welcome to write a question in the question box on the right side of your screen. Should have mentioned that before. Okay, so the definition of a disability here is the definition, just so you've kind of got it. A physical or mental impairment that substantially limits one or more of the major life activities. So what are major life activities? They're like sleeping, eating, walking, talking. Those are major life activities. It's got to be a physical or a mental impairment, and it has to substantially limit one of those major life activities. So if the major life if the activity that the physical or mental impairment limits is something that's not major, like I don't know, like something to do with your hair or something, like that. Like it's not a major. It doesn't, thinking, the ability to think. And if you go back to my my brain issue as a pretend engineer, that would be substantially limiting my ability to think. That's a major life activity. So the current impairment, or you have to have a record of impairment, and record of impairment gets a little tricky and not regarded as. So it does get a little tricky. What we always want to watch out for is that we're not assuming somebody, we're not treating somebody as though they have a disability unless we're in a situation where the person has asked for an accommodation. And that's what I had said before, like at the beginning here, is that when somebody comes forward to you and they say, hey, I've got this issue, I've got this medical impairment, I've got this disease, whatever it is, and I think it's impacting my productivity, then, what do we do about this because I need something? Well, we can ask for medical opinion. You can ask the employee to go get some third-party medical opinion on this, and they can bring it back to you, and then you can make a determination as to whether or not the person's disabled, or at least whether or not you're going to pursue, go forward with an accommodation. But we probably are going to err on the side of going forward with this reasonable accommodation conversation, this interactive process. That's a little bit different than regarding somebody, which is like treating them. So, for example, if treating somebody like a stereotype. So even if they're not, if they don't have narcolepsy, but you keep referring to them as like Sleepy Sam or something, and telling them that, hey, quit sleeping on the job, Sleepy Sam, and you and your narcolepsy, that sort of thing. These sorts of stereotypes could even be, sounds like almost harassing, that sort of thing, and that would be regarded as a little, it's a harder thing for people to prove, and there's not a ton of case law on it, but it's just something to watch out for, that if you hear those types of stereotypes perpetuated in the workplace, we want to make sure that there's some substance behind them. Episodic impairments or impairments in remission still qualify. So if the narcolepsy hasn't been around for 6 or 7 months or a couple years, well, it doesn't mean the person's still not disabled, right? So it doesn't mean that we can just treat them as not disabled and ignore them and not engage in the interactive process regarding reasonable accommodations just because their impairment is in remission or their cancer is in remission, something like that. They are still going to be protected by this law. We still can't discriminate against them, fire them because of their because their cancer is in remission, or they just haven't had a seizure or fallen asleep on the job for some extended period of time. Okay. Oops. So what is a qualified individual with a disability? And by the way, I don't think I thought this Batman thing was funny. If you're wondering like why I put it on here, the answer is because I think it's funny. Not necessarily because it's appropriate to the situation, this slide. So anyway, what is a qualified individual with a disability? So somebody who's disabled, and then somebody who, then you can read it, there's the definition, can't perform, and again, it's the essential functions of the job. If it's a non-essential function of the job, then it's not that big of a deal, and we don't really have to worry about accommodating it. A lot of employers will still try to accommodate somebody, but really we don't have to worry so much about it because we could just like take away those non-essential functions of the job. And then the disability will include any sort of physiological disorder or condition, a cosmetic disfigurement, or anatomical loss, so lose a digit or whatever, or any mental or psychological disorder. And for those of you who are on the HR Hotline program, last Friday I did the HR tip of the week that comes out. I did it on obesity, and there have been a few cases on this, and the question in that, for those of you who read it and remember, the question there is morbid obesity, not just straight up obesity, your commonplace obesity, I guess, but morbid obesity, which has a BMI, a body mass index definition. But morbid obesity, is that actually could that be a disability, and could that trigger, so somebody who's really big, could that trigger an obligation for an employer to accommodate them? Bigger chair, different desk, you name it, right? Longer periods for breaks to walk places. Think of what you can imagine. But the issue there, and that is a situation where the company and the lawyers defended on it's not a disability, because it's not a physiological disorder or condition. And the courts, fortunately, because it'd be an absolutely ridiculous expansion of the law, in my opinion, the courts, legitimately, appropriately said that morbid obesity is not, in and of itself, absent any sort of other, condition like diabetes or whatever, but morbid obesity in and of itself is not a disability. It's not a physiological disorder. That being said, the EEOC disagrees. So they disagree with the courts. This issue has not gone to the Supreme Court yet. The EEOC doesn't seem, so despite courts telling the EEOC that they're wrong, the EEOC doesn't seem to care. So we'll see over the next presidential administration. The EEOC probably isn't going to change all that much. So we'll see what happens. But this is an issue where the federal government is continuing to press this and could even try to change the law. So it could be, a year or 2 or 3 years from now, when I'm, talking about disabilities in the workplace, that we're talking about accommodating people who have who are morbidly obese. I would not be surprised by that. I would not be surprised if Congress decided to expand the ADA to include morbid obesity. We'll see. Knowledge. Knowledge is, again, like I had said before, it's direct knowledge from the employee. I have a disability. I have, Crohn's disease. I have whatever it is. That's knowledge. The harder one is whether or not the employer knows from the circumstances. You could also get knowledge from an employee's family member or something like that, friends. It doesn't have to be in writing. You can't, you don't, you're not going to, avoid your burden and obligations under the ADA to reasonably accommodate somebody because you don't have something in writing. If you have a policy that requires it in writing, you don't act until you have it in writing. That change that. That's not. It's fine. You can get it in writing, but you can't ignore it if the person doesn't give it to you in writing. A little different than the FMLA, where we have the medical certification form that we can require. We can't really do that with the ADA, though you can ask for medical documents to support it. The knowledge can come from the circumstances, and the employee just doesn't have to use plain language. So we really have, it's difficult because the employee, if the employee just kind of comes to you and says, hey, what's with the narcolepsy? They come into HR and the manager's like, hey, this is a really problem, and the employee says, gosh, doesn't use the word narcolepsy, he just says, oh, geez, I just keep falling asleep and I don't know why, and I can't seem to shake it, and it's been going on for like the last 6 months, and it happens outside work as well. Well, you don't have to play Trapper John MD or whatever and try to figure out what the malady is right here, but it's probably enough information, and if you're probably astute enough to figure out that, hey, that might be a problem. So if it sounds like it might be some sort of physiological condition and the employee is setting out the circumstances for you, I would encourage you to be safe and to potentially engage the employee in trying to get some medicals and seeing a doctor to make that determination. And if the employee doesn't, we'll have to see on the situation, but you might be able to then, just tell the employee, like, hey, look, it's essential that you not fall asleep when you're, on ladders or hanging from windows, washing windows. This is a problem. So modifications or adjustments, these are the types of things that we look at. So when we're engaging, again, we're going to talk about the interactive process in a second, but this is basically it. So we're talking about accommodations. What are the types of modifications or adjustments? Clearly, job application process, I had mentioned that before, where you might have to make an adjustment so that the employee or the applicant can make it to the job interview. You don't have to change the job at this point just to get to the interview. So modification there. Changes to the work environment. Again, depends on what the request is, what the disability is, so that the disabled employee can enjoy the same benefits and privileges. Things that are not required. Again, we've talked about it. Changes to the essential functions of the job. If Laverne's job is to pull the bottles off of the line and put them somewhere, then she needs to do that. And if she has arthritis and the doctor says she cannot do that, well, that's the job. It's essential. It's in the job description. You've got to allow her, you've got to do that part of it. And so that's okay. You can tell her, look, that's essential. We can't take that part of the job away from you. If you do, you're basically changing the job. And the ADA does not require that you change the job. The ADA does not require that you give the person another job or change these essential functions. The ADA only requires that we try to reasonably accommodate somebody within the current job so that they can perform the essential functions. If it's an inessential function to do some sort of, a non-essential function to do some paperwork regarding the number of bottles, well, okay, that's something that it's not essential, right? So, it doesn't have, it's just like some reporting. Well, maybe she can ask Shirley to help her out. Maybe that's the accommodation that happens on a non-essential function, or maybe you just take it away altogether. But you can't, fire her and take her out of that job just because she can't do something non-essential like some minor paperwork. When the essential job is to move bottles around and see the bottles, being blind would be a problem. She wouldn't be able to perform the essential functions of that job if she were blind, or if she couldn't do with her hands. Then that's, you don't want to take that essential function away. That totally changes the job, and that's not required by the ADA. Lowering the productivity standards. If Laverne needed to do like 500 bottles per hour, like she's moving them around the line. I really should have had some Laverne and Shirley pictures. This like just came. It's just all came to me, as you can probably tell. So I should have shown the Laverne and Shirley pictures. So anyway, so lowering the productivity standards, if Laverne has to do 500 bottles an hour, and you know, everybody else does that, and if they get disciplined if they don't do 500 bottles an hour, you don't have to change that for her. All you have to do is reasonably accommodate her within so that she can do the job. You can continue to discipline, you can continue to hold her to the same standard. You just have to try to reasonably accommodate her so that she can do that job. And if she can't do it, what you're finding out, so say she can only do 350 and that's her max and she can't do more, and you try it out, but because of the arthritis she can do 350 and no more, and everybody else has to do 500, then she's not qualified. Then she's not a qualified person with a disability. You've tried to reasonably accommodate her, but she's not qualified. She's not meeting your productivity standards. And so then you can try some other sort of accommodations, but probably you're not going to get anywhere with her. And at that point, you can then move her on and move her out of that job and see if there's any other jobs that she might be qualified for. But you don't have to change the productivity standards for her. She's not Teflon in that regard. You don't have to lower the standards of quality. Same reasoning. You don't need to provide a personal use instrument. So if somebody, excuse me, if somebody needs a wheelchair, you don't have to provide a wheelchair. If they need glasses, you don't have to provide them with glasses. If they need to hear for their job, you don't need to buy them a hearing aid. That's not your responsibility. You don't have to move the person to a different position. As I had mentioned before, changing the essential functions is essentially changing the job. You don't have to changing what the job is all about. You don't, the fundamental nature of the job. You do not need to do that. You don't need to move the person to another position. You should tell them that there are open positions and here are the jobs, and they're welcome to apply for those positions, or they're welcome to contact HR as jobs come available and to check in, but you don't need to give them preferential treatment, and you don't need to move them to another job. And you definitely don't need to hire somebody else out to help her. You don't have to hire Shirley, so Laverne situation, right? You don't have to hire Shirley to pick up the slack for those 150 bottles. That's not, and Shirley stands on her own, but you don't have to hire another person to help her out. For pretty much any situation, that's going to be unreasonable. Okay, Susie sneeze a lot. We're going to read the little example. Okay, so Susie can't seem to shake her cold. She's got a really cold. As people can tell from my coughing, I seem to have a lingering thing that's lasted over months, so maybe it's an FMLA issue for me, but I haven't missed any work. Okay, that aside. She's missed a couple of days this month, and you just found out that she needs more time off, of course. She hasn't gone to a doctor as far as you know. Susie's supervisor is sick of her absences. She's sick of Susie's virus-infecting ways, and she's sick of Susie's poor performance recently, of course. She wants Susie to be disciplined and ideally fired. And she wants HR to do it, of course, again. How would you approach this? Let's assume that Susie isn't eligible for FMLA. Okay, so this is a situation where it just sounds like a common cold. And on its face, just the general definition of a common cold, it's not covered by the ADA because it's a temporal situation that's going to expire. If something, broken legs, or a broken leg, a broken bone, broken arm, another situation where it's not going to be covered by the ADA, it's not a disability because it's going to, it's going to heal. Arthritis, different. Crohn's disease, different. But this sounds like a cold. However, it's best not to assume that she's not that a reasonable accommodation is not necessary. So in this situation, the safest approach, I mean, you could take the approach that, hey, common cold, whatever, it's not really affecting your essential function. So Susie, although it could be affecting her essential functions because it could be affecting the productivity. So you could just deny her. I wouldn't. I would say, fine, you should go to the doctor. Susie, let's find out what this is. It could be something long-term. It could be something that just happened. Maybe Susie has HIV. Who knows? And so it'd be best to send her to the doctor to come back with medical so that you can make a better determination as to, first of all, whether or not she might be covered by the ADA, and then second of all, what, if any, potential reasonable accommodations she might need so that she can get her performance up. Because if the cold, or whatever this condition is, if it does end up being a physiological condition, sufficient for the ADA, and the cold is affecting her performance, her productivity, then you do have an obligation, because it's covered by the ADA, to try to accommodate her provide a reasonable accommodation, so that she has a chance. So just firing her or getting rid of her, disciplining her because of her performance, knowing that there's this sort of lingering condition for a month, if Susie comes back and says she has HIV, then you're going to be thankful that you didn't just spontaneously go and fire her. And we would want to see if there's any chance that we could reasonably accommodate her. This is Packer fan Pete. I'm still mourning the fact that the Packers seem to be pretty crappy this year. I'm going to really be mourning tomorrow if the Packers lose to the Bears. I mean, you know a team is really, really bad if they lose to the Bears, and so if that happens tonight, thank you for your sympathy emails tomorrow. In advance. Okay. So last Sunday, Packer fan Petey injured his right hand after too many instances of aggressive high-fiving during the Green Bay Packers' big win, which, as anybody who knows from Texas or Wisconsin would know, that is an imaginary big win. In my mind, it should have been a big win, but in reality, it was not. He missed work on Monday and had to leave on Tuesday because he wasn't able to work. He sorts bottles with his hands because, of course, everybody in Wisconsin sorts bottles with their hands. They're all like Laverne and Shirley. And there's no automation, apparently. He's going on 2 days of absences with no end in sight. He's not eligible for work, comp, or FMLA, right? Okay. Wednesday, PD doesn't show up for work again, so this is day 3, and he calls in and says his hand's killing him, can't even grab a spotted cow with it. It's that bad. And so it's pretty bad when you can't grab a spotted cow. And it's good to hear that PD's still interested in drinking while he's taking these days off of work. PD has officially run out of sick leave and PTO. How would you handle this? So this is, again, a situation where, look, it's probably not a disability. You're probably going to be safe. He's aggressively high-fiving, big wins. Who knows? If you want to play it really safe, you ask him for some medicals to bring it in. You don't have to worry about FMLA. If there were FMLA, you'd probably just get the medical certification. You could ask him to get some medical, to get a medical to come back. It does affect his essential function of doing the job. So, you could let it linger for a week, see if it's getting any better, but it does sound like it might be a problem. And who knows, maybe PD has arthritis or something like that, or maybe it's some sort of, who knows. Probably a temporal position, more likely than not a disability. But if you really want to play it safe, you could tell him to bring in some medicals to justify this. Otherwise, if it keeps lingering and he doesn't bring in any medicals and he's out of PTO and you have an attendance policy, you could start to look at, after you've exhausted, making the determination whether or not he's disabled, you could look into telling him that it's unreasonable for you to continue to let him stay off of work, and he's got to come back and he's got to do the line, and your unpaid leave policy is such that you don't give it to employees for more than a week or two, and he's starting to accrue absences that are unexcused. So you could go down that route. It's a little bit more aggressive, but you might get to it after, depending on the medicals or depending on whether or not he even returns any medicals to you. So in this type of situation, I could see a denial of the request. I could also see asking for medicals, and if he brings it in, seeing what they say, and if the medicals say something like he has a disability, then you have to make it a determination and talk to him about time off work as a reasonable accommodation, depending on how long that would take, and we'll talk about that in a second under the interactive process. Okay. Here are the steps. Everybody should know these after this, and write them down and memorize them. Steps with the interactive process. We're going to meet with the employee. Bring the employee into your office. Talk to them about the situation. They've claimed to their manager or to HR that they have a disability, that disability is affecting their ability to perform the job, the essential functions of the job, and it's hurting their productivity. Maybe they bring it up in a performance review. Maybe they just mention it offhand. Maybe they come in and talk to HR and say, I was just diagnosed with Crohn's disease, and it's or epilepsy. Let's just say that epilepsy, and as a result, I don't know what this means for me, but I think it's going to be problematic that I'm doing window washing and walking up on or walking on beams and ladders and that sort of thing. Okay, so you've met with them, they've identified, they've given you knowledge that they have a disability, or at least a potential asserted disability condition that's going to affect their essential functions of the job. Next thing, inquire about the limitations, what they think the limitations are, and identify the functional limitations. So that basically means, employee, please go to your doctor. Here's a copy of the job description. Here's a copy of anything else. Here's a letter to take to your doctor regarding the job. Please have your doctor get back to us regarding what limitations you have given your epilepsy and how it's going to impact you in this job. If the doctor says, the epilepsy, there's no notice, and the person might have seizures, and if the doctor says that he should not return to work, he should not work on ladders, and ladders are, climbing ladders is an essential function of the job, then in that situation we've got medical information from the doctor that he basically, is limited in his ability to do at least one essential function, climbing ladders, because of the epilepsy. We determine whether the limitations affect the ability to perform the essential function. In this situation, yes, the epilepsy, per the doctor's note, is going to clearly impact the ability to perform the essential function. That doesn't end our inquiry. So the fourth thing, we need to move on to then the conversation. So first one, there's a meeting back and forth. The second and third are gathering information from medical professionals and engaging in this conversation. But we're doing some fact gathering in 2 and 3. And then in 4, we circle back and we have another meeting with the employee and we talk about what accommodations are being sought. So how are we going to accommodate you, employee who climbs on ladders, who now is going to have unannounced seizures? What are your suggestions? What has your doctor suggested? And whatever those suggestions are, you need, as a company, need to determine whether or not they're reasonable for you. And I would encourage you to have that be a fairly low standard, because we want to show good faith. We want to show that in good faith we are trying to accommodate this employee so that they can do the essential functions. So if the employee and or the doctor come up with some ideas, I would encourage you to implement them. And to go to number 5, if there are 5 different potential accommodations between you and the doctor and the employee, you come up with like five different things that might work, like harnesses or no ladders, whatever it is, something that can allow the employee to be qualified, or potentially allow the employee to be qualified, then you should implement it. And you can choose which one. You as the employer get the option to choose which one. You don't have to give the one that the employee most, craves here. You decide which one to implement. And if it doesn't work out and the employee still isn't being productive, or they can't do the rest of the job, they can't do the essential functions of the job, if that doesn't work, we have to repeat it. So there were 5 initially that were discussed. Go back and repeat 1 through 5 again. And you could probably potentially skip 2 and 3 if you've got 5 on the table after the first go around, and then you've got 4 left, because the first time is it didn't work and you found that the employee, that you couldn't do the job, and then you got to circle back, redo this all again, and you keep redoing it until everything's been exhausted and you and the employee and the doctor are at a loss for how you can possibly accommodate this employee. And once you've exhausted that, then and only then do I recommend that you think about cutting the employee out and saying, look, this is the job, you've got to climb ladders, we've tried all 5 things. Anything else? Is there anything else? No, there's nothing else. Okay, we've been at this for a couple months, it hasn't worked out, you still can't do the job. It's essential that you climb the ladders to get up there to the roof and everything. We're done. You're not qualified for this job, and that's why it's got to be a qualified individual with a disability. So the person has a disability, they're an individual, but they're not qualified because you could not accommodate them, and their disability prevented them from doing at least one essential function of the job. And at that point, you can terminate their employment. And then what you should do is encourage them to apply for other jobs that they might be eligible, qualified for, with or without an accommodation. But you don't have to move them to another job unless you want to. But yes, these steps should be, it's like repeat and rinse and keep doing them over and over again until you have exhausted everything. We've got 5 minutes, so we're going to blow through a few slides here. Considering the potential accommodations, kind of a repeat of what some of the stuff I had just said. The good faith accommodation process on the right. Consider the employee's request in good faith. I really recommend that this is a sincere approach for you. Just try to work with them. This is all part of a conversation between you, the employee, sometimes the manager as well, supervisors, and the employee's medical professional. You can get other medical professionals involved on your own dime if you would like. There is a process in place for that, but it gets kind of expensive. But you could do it. You see my tip over there. I'd already mentioned this, but your obligation is to offer a reasonable accommodation. If there are multiple accommodations that are reasonable and could get the employee to perform the essential functions of the job, you get to choose. So a lot of times employees want, this great accommodation, whatever that they really strive for and their doctor recommended. But if there's another accommodation out there that works better for you, you can take it. And I didn't say this before, but all of this should be documented. You want to do as much documentation of this entire process as possible to show that you have engaged in this interactive conversation with the employee and that you've gone through all of these steps. If this is just orally done and it's just kind of on the side done and there's no detailed documentation of your conversation, of this process, of everything that you've engaged in, then you're really doing yourself a disservice and you're putting yourself at greater risk in the event that there is litigation or an agency investigation. Employers determine, when we talk about reasonable accommodations, employers get to determine what is reasonable. And again, reasonableness is subjective. So it's going to, you can see the list, nature of the work site, nature of the job, size of the employer. It's similar to the undue hardship argument that we had talked about earlier. So again, this is what makes it difficult. This is what makes it hard for all employers, because I cannot sit here and tell you what is reasonable for you. You can't even tell, you and I can't even talk about what's reasonable for just your business across the board, because every job, every department, every everything, every different location is just going to have a different standard. And so circumstances, we have to look at a case-by-case basis on this. Can you refuse to accommodate? Absolutely. If you do it without doing the interactive process, first of all, that's a no-no. You're going to put yourself at automatic risk. You should never be jumping to undue hardship on your business. You might get there, but you should definitely go through all of these steps first. Here are the considerations, the factors that we talk about with undue hardship. And again, you might get there. If the employee is disabled and they are requiring that they have an office on the 15th floor, but the 15th floor is only for executives, well, it might be unreasonable. It might be a hardship on the business. On some businesses, on other businesses, it might not be. But we can get to this. We can argue undue hardship. I would just recommend that we caution against immediately jumping to this, because it's an affirmative defense that's better for attorneys to raise in litigation rather than to automatically jump to it without going through the steps. After doing the accommodation, we still want to monitor its effectiveness. And so if it's not working out, and say it works out for a year, but then after a year it doesn't work out, does that, or a year later, does it not work out, or even a month later, you find out that it's not working out, what do? Repeat the process. Go back to steps 1 through 5 and redo them again. Get updated medicals if you need it. Find out where the accommodation has been failing. We can't just rest on the fact that we did this interactive process a week ago or a month ago or a year ago. We have to repeat it, and we have to continue to repeat it until we have exhausted it, and then at that point we can get rid of the employee. But otherwise, if we are getting rid of the employee and just saying, oh, we did that process in the past, then we're putting ourselves at great risk and likely violating the aspects of the ADA, the reasonable accommodation requirement. Here's a side-by-side of the ADA and the FMLA. I'd already mentioned the key thing, which is that the FMLA, well, first of all, the FMLA has much greater protections on, we don't talk about what's reasonable or unreasonable with the FMLA. If the person needs time off because of a serious health condition, or coverage under the FMLA, they're going to get it. You've got a really limited defenses to denying somebody on FMLA when they've turned in the medical certification and they're otherwise eligible for the FMLA. So we don't get into this issue of reasonable accommodation. With the ADA, we do. So we have more flexibility. With the FMLA, one thing that a lot of employers do, and for those of you who have been coming to my webinars for years, I say this all the time, if somebody comes off FMLA and they've exhausted and they're not ready to come back for whatever, we don't know the reason necessarily, if it potentially could be because of a disability, we are obligated, again, under the ADA, to engage in the interactive process to talk about whether or not the person needs an accommodation. And an accommodation could be time off. Reasonable accommodation might be additional time off. So if somebody has just taken 12 weeks off for FMLA, we should never automatically fire them because they cannot come back to work that next day. They've lost their eligibility for FMLA. That's fine, but we should then jump in to steps 1 through 5 and engage in the interactive process with them to make a determination as to whether or not they need time off as a potential accommodation. If they're saying they're just not ready to come back from surgery, maybe cancer or something like that, they're going to be qualified. They're going to be disabled. And if the doctor's note says, well, they need an additional 3 weeks off, good luck declining and saying that that's unreasonable for you to give another 3 weeks off. That's going to be very, very difficult for you. Now, it could be under the circumstances reasonable to deny it, but most situations, an additional 3 weeks is going to be reasonable, and you're going to be encouraged to accommodate them with additional time off, even after the FMLA has expired. I'm going to skip the Tobias example because I am 3 minutes over, so my apologies for that. Next webinar will be in a month on the 17th of November. We're going to talk about everything having to do with background checks. If anybody has any questions, you're welcome to reach out to me at kmosher@thompsonco.com or to call at any time. I appreciate your attendance, and I look forward to speaking to all of you soon.